with rentals today. And our idea with putting rentals in the middle was that even though we talk about how mostly buyers are the first clients that we work with, actually renters come in a lot of time before you have a seller. So I wanted to make sure that we had rentals for you guys to understand what we talk about when it comes to tenant agency and listing agreements and the leases. Also, with that, our tenant agency agreements and our listing agreements are very similar to what we went over yesterday and Monday for buyers and regular sales. So it's kind of a repeat of what we had. The other thing I wanted to tell you guys is that, you might have heard me say it already, I am a proud member of the NVAR Forms Committee this year, and they have decided to have a meeting, their first meeting, at 10 a.m. this morning. So I have a guest for you guys today to take over for me at 10 a.m., and that is our wonderful Director of Production from Kingstown, Drew Swirsky, who many of you guys know. So Drew, yay, thank you, Drew, for being here today. He is going to take over for me at 10 when I go to pop over to the other meeting. I'm going to go over the lease with you guys. So I'm going to do this backwards, right? Normally we start with the agency agreements and then go into the contract documents. We're actually going to start with the lease, and I'm going to go over that with you guys in detail and the documents that go with the lease. And then Drew will review with you guys the agency agreements and then talk about the application, right? So that you guys know how to talk through those consultations. That's kind of been a theme this week, right? I've encouraged all of you to have true consultations, true appointments to talk about setting the expectations. So he's going to go through that with you guys as well. Everybody good? All right, awesome. If anyone did not receive the materials that I sent yesterday, let me know. I'm going to pull them up and share my screen, and then we'll get going. All right, can you guys see that? Yep. Did it come through? Okay.
Yes.
All right, took me a minute, I couldn't find it. Let's get going in the lease. Okay, so the lease should be completed by the listing side of a transaction. The VRLTA lease is the only lease that we are allowed to use as agents, okay? Virginia Residential Landlord Tenant Act, what VRLTA stands for. It has certain rules and regulations and laws that are in the statute for the state of Virginia so that everybody is clear as to what the expectations are. Years ago, there had been a common law lease that we were allowed to use, and the clients were allowed to choose whether they wanted to use the common law lease if they owned less than 4 properties, or if they wanted to use the VRLTA lease. I always suggested that everyone use the VRLTA lease, no matter how many properties they had. And then, of course, if they owned more than 4, they had to use the VRLTA lease. And then we moved into a situation where the Virginia Association of Realtors attorneys figured out that it was too confusing, and there really was no substantive difference between the common law and the VRLTA anymore. So they got rid of common law, and this is the only lease available to us. So at the top, it has the fill in the blanks, just like every other document we've seen, the day the lease is made on. Okay, that's the day that you're creating it. The landlord is the name on the deed or names on the deed. There have been times where I've seen just like a husband and a wife who are the owners, and just the husband is like, oh, well, I take care of everything, so just put my name, or, you know, the wife's like, I take care of it, just put my name. They're not allowed to do that based on the way the ownership is. They has to have both because they're both owners. If it's a business that owns it, if it's an LLC or a trust, that's what goes here, just like the documents yesterday. The tenant's names, their legal names go in tenant. And then of course, the listing company and the tenant's company are memorialized here in the lease. If it's being managed by a property management company, the management company does not go here as landlord. Again, it's the legal owner of the property goes as the landlord. The premises, just like yesterday on the listing agreement, the address, subdivision, we just fill in the blanks. Parking space is only if it's deeded to the property. And the mailbox number, you would put here. This would be very helpful, especially if it's in a townhouse or condo, because those are assigned specifically to the property by the post office. Storage bin, you would put that there as well. The storage bins are assigned to the properties by ownership. So you could put that there. In certain condo associations, there are separate storage units. Lease term. Okay. Here is where it's the date and time that the lease starts. They used to say noon, I think, that the lease started on whatever day. Now you can choose. So if the landlord wants to give keys first thing in the morning, or is not going to be able to give keys until the afternoon or something, then you put the time here. So this is new for those of you that have done leases
Yes.
before.
Hi, Mr. Stump. My name is Gailey Corns. I'm with Keller.
The date that the lease is going to start and the end date and time. Okay. This is, again, for those of you that have done leases prior, the time here is very important. Okay. It says here that the tenant and landlord can deliver notice to either party if they wish to extend the lease date and execute a new lease not less than 60 days prior to the end of the lease. All right, that's how we define the term. Early termination, there is nothing in this lease that talks about early termination as far as what the rules are in this paragraph, what has to happen as far as an agreement that's made for early termination. Landlords and tenants can decide on their own what agreement to make if someone needs to move out. However, the tenant needs to understand that they're responsible for the entire lease term unless the landlord agrees to something else in writing. Okay, so if they enter into a 12-month lease and 6 months later they decide they want to buy a house, there is nothing like a 60-day notice plus a 1-month lease break penalty, right? That doesn't exist in our lease. It simply states that they have to, that they are responsible for the lease for the entire time. And then they can negotiate something in writing if the situation arises. All right. This next section, I would like you guys to pay close attention to. It's a very confusing section. I'm going to try not to confuse you as I describe it verbally. So unmute yourself and let me know if I did confuse you when we go through this. All right. I'm going to give you the idea of it first before I go through what gets filled in the blanks. This says that the total rent for the lease term shall be, so it's going to give us a couple of different chunks, right? It starts off with the total. So it says for the entire lease term. So for the entire 12 months, 24 months, 15 months, 15 and a half months, whatever it is, right? And then it talks about the monthly rental payment, how much each month is of payment. And then it talks about if there's prorations, right? So if they're moving in the middle of the month, what happens and when this is due. Okay, so it talks about all of the money as far as rent payments right here. So the total rent for the initial lease term shall be blank, payable in monthly installments. So what you need to know here that's important is if they're moving in the middle of the month, you're going to take all of the months in full plus the prorate. So we're going to use an example of January 15th as a move-in date, okay? And the lease is going to end January 31st, 2022. Okay, we're going to do this real exercise with dollars. I want you guys to get out your phones, your calculators, whatever. We're going to do this with real money so that you can see what should go in these blanks. All right, I'll give you a second to either grab your calculators or, okay.
It's a January 15 start 2021.
Right now, yeah. Yep, January 15th, so that would be like a couple days from now. So essentially what this lease is 12 months plus the prorated days. Okay, and we're gonna say that the rent, we're gonna just go with $2,000 a month as the rent, okay? So we're going to skip a couple of these blanks to start with because it really doesn't make sense to fill all of them in the order yet, right? And this is why this paragraph gets a little confusing. So when we go to the next section, it says the first full month's rent for blank in the amount of blank shall be paid prior to occupancy. Okay, stop. So here we take a full month's rent up front with their application, right? They have to pay a full month's rent as their deposit with their application. So it doesn't matter if they're moving in 3 days left in the month, 15 days, 20 days, it doesn't matter. We're taking a full month's rent. So they're essentially paying their first full month's rent and their prorated month backwards. So in our example, we have someone moving in January, but their first full month that they would occupy is February. Everybody with me so far? So the first full month in this scenario is February. So that's what would go in this section. The first full month's rent for February in the amount of $2,000 would be paid prior to occupancy, okay? They have to pay that first full month. They have to prove that they have an entire month's rent available to pay. And then it goes on to say monthly installments of blank. So our monthly installments are $2,000 a month, are due in advance of the first day of each month beginning on, and this is going to say March 1st, because that's the next following month where they would have a rent due date. Have I lost anyone yet? Okay.
Ma'am, what about January 15 to January 31st or January?
Yep, we haven't gotten there yet in the paragraph.
Okay.
Okay. So now it goes on to say, if the lease begins on a date other than the first of the month, the rent shall be prorated. Okay, so it'll be prorated with blank, due on a specific date for a period. Okay, so in our scenario, we're going to come back and calculate the amount in a minute. And that January rent is going to be due February 1st because they're paying February and January's timeframes backwards. Okay, and that's going to be for the period of January 15th to January 31st. All right, everybody with me so far? So right now, what we're missing in the blanks is the prorated rent amount here and the total rent amount here. So our prorated rent, if we are looking at a $2,000 rent, the way that I advise to calculate this, and it is a standard way across the board to calculate this, you might see minor differences in how the prorations are calculated, but my guidance to you is this. You take the total monthly rent and you're going to divide it by 30. No matter how many days are in the month, you're going to divide it by 30. Okay? In the end, it all works out. And then you're going to count the number of days that they are in the home for that month. Okay? So if you go and you look at a calendar, you're going to see that you have actually, for a move-in on the 15th, you have 17 days because you have 2 full weeks plus 3 days. So that's 17 days. So you're going to take that number, the $2,000 divided by 30, which is $66.67, and you are going to multiply it by 17, and you're going to come up with $1,133.39. Okay? That number is what goes in this line right here.
Where did the extra 2 days come from? I'm sorry, because I calculated the 15th to pay 15 days and you said 17. I missed that 2 days.
Pull up on a calendar and just count the number of days starting with the 15th to the 31st, and you'll get 17.
I thought we were calculating 30 days.
So we started with 30 days just to get the prorated daily amount, the per diem amount. And then we had to figure out how many days will the tenant occupy in the month of January.
So I guess why do we calculate for 30 days and then pay out?
Because
I know at the end of the year it evens out, but like
that's exactly why. Because at the end of the year it evens out, because some months have 31, some have 30, and then you have February 28. So we always just use 30. So right here, you're going to have the 1133.39. And so now we still have one blank left to fill in, which is the total rent for the lease term.
Sorry, Shannon. When they say due on, after you say 1,130.39, due on?
That's due on February 1st. So February and January's dates were swapped. Okay, so we had filled in February there for the period of January 15th through January 31st. Okay, and so now our last blank that we need to fill in is this one for the total rent for the initial lease term. So we have 12 months because we have February 1st all the way through January 31st of next year. So that's 12 full months times $2,000 is $24,000. And then we're going to add the 1133.39. And that's going to give us $25,133.39. And that's your total. Okay, so now if we go back and look at that paragraph, it's going to say the total rent for the initial lease term shall be $25,133.39, payable in monthly installments. The first full month's rent for February in the amount of $2,000 shall be paid prior to occupancy and is payable in certified funds, cashier's check, or money order. Monthly installments of $2,000 are due in advance on the first day of each month, beginning on March 1st, without notification, demand, or deductions. If the lease begins on a day other than the first day of the month, the rent shall be prorated with $1,133.39 due on February 1st for the period of January 15th through January 31st, 2021. All right, everyone good with that? Okay.
Yes, Shannon, I have a question though.
Yes.
Let's say if there was only 2 or 3 days left of the month, let's say they moved in, the 29th of January.
Mhm.
Is it allowed to accumulate that amount into the February payment and instead of charging them in February, those 3 days, the next payment is the full payment is due in February because they already paid that 3 days with their first payment?
You can. I'd like to not confuse the rest of the group. It's better to do it the way that it's exactly written here, but it can be adjusted where you can ask for that first full month and the prorate at the same time if it's just a couple of days.
Thank you.
Sure. Okay.
Shannon, I have a question.
Yes.
So the on January 15th, then you would have collected only $2,000 security deposit.
So we haven't gotten to the security deposit section yet, but the security deposit is paid to the landlord directly, and that would be paid at move-in generally.
Move-in. So January 15th, and then on February 1st, the tenant will have to come up with $5,133.
No, I don't know where that number came from. So the tenants are paying with their application their first month's rent, and that goes to the listing company because that's how commissions are paid. Okay, so they're already paying their first month's rent up front before they ever enter into the lease. So when they move in, what they're paying is any other deposits and things like that that go directly to the landlord. All of the rent for their first month is paid prior to entering into the lease.
Yes, but it says here that the first month rent will be due on February 1st.
It says the first full month's rent for February is paid prior to occupancy.
Oh, okay.
Okay, so that's what comes with their application.
Okay, got it.
Okay, yep, sure.
Shannon, can you just repeat the last paragraph to make sure I have the numbers correct?
Sure. The prorated amount there was $1,133.39. And it was due on February 1st for the period of January 15th to January 31st.
Thank you.
You're welcome. Okay, late payments, return checks. This is something that is standard. It is pre-printed language, so there's not any confusion on how much the landlord is going to charge if there are checks that are returned, if there are late fees, etc. Rent is due on the 1st, period. Okay, there is a grace period for late fees through the 5th. I want to be clear on the verbiage there. It is due on the 1st. But the grace period for late fees goes through the 5th. So on the morning of the 6th, if the rent has not been received, the landlord can charge a late fee. And the landlord may charge the tenant the lesser of 10% of the total monthly rent, 10% of the remaining balance due owed by the tenant. That's what the late fee can be. Excuse me. For any return check, there can also be a fee and then a late fee of additionally charged, because now if that check is returned and it's returned after the 5th, the rent's late. They can also charge administrative fees of $50. There can be interest. It's basically they're looking at pass-through fees, also, right, to the tenants if your bank charges you, if you're the landlord. When a landlord accepts partial payment, they can accept it with, there's a document called Rent with Reservation, which allows them to still pursue any foreclosure proceeding, eviction proceedings with them if they needed to, and still be able to collect the rent that they're trying to pay as a partial payment. Okay. This says that there is an ability for the landlord to give a default notice to the tenant. We commonly call this notice a pay or quit notice. I'm not going to get into many details about the pay or quit notice right now because it has changed and is ever changing with our current eviction moratoriums and our being state and national moratoriums right now. So if you have a situation and you need more information, you can certainly reach out to me and I will help you with that. But basically what it says is after that 5 days on day 6, in addition to the late fees being incurred, that notice of default can be sent to the tenant saying, hey, you have 5 days to pay your rent. And if you don't pay your rent, then we can start proceedings to terminate your lease and get you out. Okay. Next section is on management. Management is for a property manager. This is not for somebody's friend that just lives in the area and is helping out. Management is for a property management company, and their information goes here. It says if the premises are not professionally managed, then the contact information for the landlord goes here. So this is where the rent, if it's a check, would be mailed. This is the phone number and email address. This is contact information for the landlord so that the tenant knows how to reach the landlord. Okay. Appointment of resident agent by non-resident landlord. So this is where you can have a landlord that has a friend that is a contact person in the state of Virginia. So this is any individual resident in Virginia who owns and leases residential real property, right, rental property, shall have an agent who is a resident and maintains a business office in Virginia. So the business office isn't really something that they enforce. It has to be someone that is local so that they can feel comfort level that if something went wrong with the property, the tenant can reach out and get in touch with someone, okay? This doesn't mean that the non-resident agent is the manager of the property. It just means that it's that additional contact person.
Does that individual need to have an active license, or could an inactive license be appropriate for this?
They don't need to be a licensee at all.
You don't need to be, okay.
No, they just need to be a resident in Virginia.
And do they have parameters on what local means, or is that like subject to interpretation?
It just has to be a resident of Virginia.
Okay.
I got a half question about the failure to pay rent. If you fail to pay rent and they do serve you with that pay or quit, basically pay or get out, does that nix or void the early termination business about owing the rest of the year essentially?
No, it doesn't. What happens when a pay or quit is allowed to be sent is that the tenant has already breached a term in their contract. And so they can, it's a little more complicated, right? So if they vacate and then it's re-rented, they can't be charged. 2 people can't be charged for the same occupancy and things. So it's a little more complicated than that. But they've already breached the contract by not paying.
I have a question. Can that the resident agent, can it be like a family member of the landlord, like a brother or a sister?
It can be anybody. It just has to be someone that can be contacted.
Okay,
that's in Virginia, right?
okay, thank you.
Okay, yep, absolutely. And remember, you guys are you're not representing the, any party in this lease at all as an attorney or as a property manager or anything. I'm just explaining to you what each paragraph says so that the clients know. If there's a tenant that doesn't pay, we're not advising them on what that looks like if they don't pay, right? What happens, or a landlord, we're not advising them. We have attorneys that we can refer them to do their eviction proceedings. We have to be very careful that we're not overstepping. And I have resources for you on that. Okay, this is just to understand the documents that you're putting in front of your clients to sign.
Can I ask only one question? Sorry.
Sure.
About management, is always that if the landlord has management company, right? Is always that the check from the tenant go to the management company and after go to the landlord, or it can be that the check goes direct to the landlord, but you still have the management company. How it works about that?
Each situation is different. It depends on how the management agreement is set up. Most of the time it goes to the management company. That the management company needs to earn their pay, right? What are they doing, right? If they're not, so usually it goes to the management company, but it'll say right on there where the money goes. In the truthfulness of representations in the rental application paragraph, it says that the tenant warrants that everything that they said in the application is true and accurate. And if there are material facts that are untrue, that the landlord can immediately terminate the lease. So if the landlord finds out that the tenant lied on their application, the landlord can terminate the lease. So that's a very important clause for landlords in this lease. Uses. The tenant will use the premises as a single family residence only for the persons listed on the application and those children born, adopted, placed under legal care of tenant thereafter. Okay, so what does that mean? Well, that means that every adult over the age of 18 needs to be on the lease, and they should be sending in an application. And on those applications, any minors are listed. There's a place to list who the minors are, right? And so that's how the occupancy is determined on who's allowed to be living in the property. It talks about guests not exceeding more than 2 weeks at a time for any consecutive 12-month period. So if you have a family member who's coming to stay from out of town, and it is going to be a month, the lease says that as a tenant, you have to get written permission from your landlord to have that additional person occupying the home because they are not on the lease. It also goes on to say that the landlord can terminate the lease when an immediate threat exists to health and safety of the landlord or other tenants, or that there is disposition of drugs or drug paraphernalia that's considered an immediate threat, whether or not there's a criminal conviction. Okay, so there are certain things that do allow the landlord to terminate the lease, and it would require 72-hour notice from the landlord to the tenant. Pets, the tenant can or cannot have pets, and there's an addendum for that we'll touch on in just a minute. Smoking, yes or no? You have to have that marked, yes or no, if it's allowed or not. Is it in an HOA or condo? This information is here. Landlords need to provide the association rules to the tenants because the tenants have to abide by those rules. So that's in here as well. Will they be provided? Or have they been provided? Vehicle parking, it's reminding that vehicles must be current with license plates and county stickers and those types of things, and where they can be parked. That's pretty simple. Utilities and services, are the utilities included in the rent, or do they have to be paid separately? And is there a specific service that they have to pay, right? Is there a specific company that they have to pay for these services? That could happen if it's like propane, gas maybe, or if it's a certain cable and internet provider that the landlord is requiring because it's already run to the house, okay? It does talk just a little bit about sub-metering and things like that, but in most cases, there won't be sub-metering. It's just a flat, either it's included or it's not in the way that our leases are done. Landlord maintenance. The landlord must maintain the premises in compliance with the Uniform Statewide Building Code. So they can't neglect the condition of the home. They have to maintain it to certain standards. Now this section, 17. 17 is another section that is not filled out properly in a lot of cases. This is where you list the conveyances, basically. What's going to be in the house that the tenant's going to get to use. I see sometimes where appliances are just left blank. I see sometimes where it says as listed in MLS, or, you know, all that exists, or, you know, something vague. Right here, you need to list out all the appliances. So this would be refrigerator, stove, microwave, dishwasher, washer and dryer, right? If there's something as is, that means that the landlord's saying it's working now, but if it breaks, I'm not fixing it. And that's what goes in the as is section.
Can I ask a question? About 16?
Sure.
I see that so far there's a lot of rights for the landlord. So in 16, that kind of covers the tenant. Where would they get the Uniform Statewide Building Code to be protected if they keep on having issues with their rental property?
Google.
Google. Okay. Thank you.
Yeah.
Okay.
I mean, it's easily accessible online.
Okay. Thank you.
Yeah. And tenants that are having a lot of trouble can go to the county, and the county can generally help them. Okay. Smoke detectors.
Yeah,
All right.
so I have a question
Yes.
about 17. So can you give me an example of an Ses appliance?
Sure. There might be a microwave that is not a built-in, and it's just a countertop microwave, and it's old, and the landlord says, here, it's here, and you can use it. And if it breaks, throw it away, and I'm not replacing it. You can buy your own microwave.
Okay, but it doesn't apply to gas stoves or.
It applies to anything negotiated that's written in that section. So it all depends, right? It all depends on what the landlord and tenant agree to. Now, what I'll say is in most cases, your general appliances, that's not going to apply to. Yeah. But if a tenant comes in and all the appliances are old and they get a really good deal on the rent, they might agree that fine, it's as is, and I'll buy my own stove, right? And when I move out, I'll take it with me.
Okay, thank you.
Okay, you're welcome. Okay, landlord has responsibilities to the tenant when it comes to smoke detectors. So the smoke detectors all have to be tested prior to tenants moving in. I bet none of you knew that. So there's also a requirement with our sales too on smoke detectors. We're going to talk about tomorrow. If a smoke detector is defective or needs repair, the smoke detectors have to be fixed within 5 days by the landlord. And the counties have information on the smoke detectors as well. And of course, the local fire departments are very helpful with that. Security deposit. Awesome. Okay, this is an important section, security deposit. So the security deposit is generally 1 month's rent, and it's held by the landlord or the property management company. It is not ever held by Keller Williams, ever. So what this talks about is what the security deposit is allowed to be used for. So at the end of the tenancy, the landlord can apply this security deposit, any past due rent, any damage to the property, any fees like attorney's fees or court costs that have been incurred during the tenancy. Within 45 days of termination or the tenant vacating. So if the tenant vacates and it's prior to the end of the lease term, that 45 days kicks in. If the tenant vacates after the lease expires, then it's 45 days after they vacate. If they vacate early, it's still 45 days from the end of the lease term that the landlord has to give them their statement. They have to give an itemized statement and the estimate of all the deductions. So they have to say, hey, look, if I had $2,000 in a security deposit and the carpet has to be replaced and I have to paint and I have to patch the walls, you have to give an itemized statement. You can't just say, I'm keeping your deposit because the house was a mess. Okay. The landlord also has to give the tenant an option to be present for the walkthrough. All right, this also indicates that the tenant should provide the landlord with a forwarding address, especially if they are getting their money back and they want to get that money. The landlord has to know where it goes. Okay. Questions on security deposit? Move-in inspection within 5 days. After the beginning of the lease, the landlord shall submit a written report to the tenant of the condition of the premises, including identification of any visible mold. It's very interesting that they highlight that. The tenant submits additional items in writing to the landlord within 5 days of receipt of that report. Okay, so it's a little different than before. The landlord gives a walkthrough sheet to the tenant and says, this is what I am marking down as any deficiencies in the property, as the condition of the property as you move in. And then the tenant, when they move in, right, as they're in the home, they're marking down anything additional that they see. And they have 5 days from the time that they receive that report. They should be receiving that report at their walkthrough when they get their keys from the landlord. But maybe they don't get that report for a couple of extra days. So maybe they get it on day 3. So then it would be day 8 that would be the trigger that they have to have that back. All right, so it's very important that they do those walkthroughs. Why do I ask for walkthrough sheets in command? I ask for walkthrough sheets not because you're doing the walkthroughs. I ask for walkthrough sheets because you're having conversations with your clients, and clients lose paperwork, and you can be the keeper of paperwork for them, and you can be encouraging them to be doing these things and honoring the promises that they make in these agreements. And one of the things is to do a walkthrough, because the worst thing to happen is for them to get a year down the road and say, well, the carpet looked like that when we moved in. And the landlord says, well, no, it doesn't. And nobody has any evidence, right? You're the fiduciary for your clients. So that's why I'm asking for the walkthrough sheets. So just saying, oh, landlord and tenant did the walkthrough together, great, that doesn't actually accomplish anything for our purposes. Okay.
Shannon.
Yes.
I just get 4 families that came from military from overseas, and I haven't received any walkthrough sheet from landlords.
Well, you wouldn't receive it. The tenants should receive it. So ask your tenants if they've received condition walkthrough sheets, and if they haven't, then they should be reaching out to the landlords asking for it.
Okay, thank you.
Okay. Yep. Remember, we as agents are not parties to this lease. right? We're not property managers, but we can certainly stay in communication with our clients and help them and guide them on certain things. Okay, this next section on tenant obligations talks about just some very specific reminders to tenants as far as condition of the property. So this is an important thing to remind your tenants to read over. It talks about how they maintain the property and what constitutes neglect and what's their responsibility versus what do you get to call your landlord and say something's broken on. The rule of thumb here is that if it is a deterioration from use by the tenant is responsible to take care of it. So it says they have to maintain the premises in a clean and sanitary condition, right? Disposing of all trash and garbage. They have to operate all their appliances in a safe and reasonable manner. So what that also means is that if they don't take care of the appliances or use them properly, then it is their responsibility, the tenant, not the landlord, if it breaks. It's regular homeowner maintenance, homeowner occupant maintenance type things like frozen pipes, right? Should you be draining the pipes outside and winterizing and things like that? The tenants are responsible for those activities. Furnishing and replacing light bulbs and fuses and changing air filters, right? It's the tenant who's using them. The tenant doesn't get to call the landlord or the property management company and say, my light bulbs are out. Cleaning and caulking of toilets and tubs and showers, etc., right? So these are all things that are listed, including the lawn maintenance, and that there's a responsibility to provide in writing to the landlord any defect that the landlord is then responsible for, because it would be considered neglect if the landlord is not notified and given the chance to make the necessary repairs. You guys can read all of these things later. A holdover tenant. A holdover tenant is someone who is still occupying the property after the expiration of the lease term and a lease extension has not been signed. Okay, so our lease expires when it expires, right? There's no month to month after under any terms that are automatic in this lease. It just expires. So if there's nothing in writing that says what the terms are for the extension, the tenant is considered a holdover tenant. And this explains how the rent and liquidated damages can be calculated for a holdover tenant that does not have an agreement in place with the landlord to stay past the end of their lease term. Section 23 talks about.
Yeah, I have a question.
Sure.
For the holdover tenant.
Yes.
So in this case, you can raise the rent to $4,000 a month. Let's say in our case, for $2,000 a month rent.
Well, at the end of the lease, it can be raised by mutual agreement, and then and then a new lease is entered into, or a lease extension is entered into via addendum.
No, but for the holdover tenant, when you don't have any paper signed, it says that the holdover rent equal to 100% of the per diem rent. So it means that the tenant will be liable to pay $4,000 a month.
Well, $4,000 is 200%. $3,000 is 150%. So it's per day. It's a per diem. So it doesn't automatically go for the whole month. It's a per day.
Okay.
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 If we're working with someone who's a landlord and they want to use this lease but make adjustments, what's the degree of like editability that we can put into this? If they know instead of having the holdover tenant section, they want to put in a month-to-month addendum.
So there is a section where it can be negotiated up front that at the end of the lease, the tenant has permission to go month to month at whatever rate it is. We don't like to have these documents modified, right? So if there's something, it's not really holdover tenant, right, that's being modified, it's the lease term that's being pre-negotiated for what the months are after. So that's something that can be added in a lease addendum or in the additional term section.
Got it. So similarly, like I know with the early termination, that was pretty high level. So if we wanted to have a more granular kind of
yeah, and I'm going to advise against writing contract language at all. If you have a unique situation where I wouldn't do it for every lease. I wouldn't put in lease break clauses for every single lease, right? I would say if there's a unique situation where a tenant comes in and knows that they might be transferred, or they, something might happen, or they've applied for a job somewhere else, or, something, and they want to have that conversation up front and they want to work it out, that's okay. You can negotiate that up front, but I would not be adding standard language to every single client that you're working with, because there's a reason that it's not in the VRLTA lease. There's a reason it's not in the statute.
Got it.
Okay, awesome.
I have another question, Shannon.
Yes.
So for the extension of the lease, when it expires, are there any specific documents that the tenant and the landlord have to sign, or can it be just done through text or let's say email, like a regular question? So can
everything has to be done in writing. Everything has to be done in writing on an addendum to the lease, and that's in your packet. Email and text is not enforceable.
Okay, yeah, thank you.
Yeah, you're welcome. Okay, I want to get a little further before I have to jump off to my next call with you guys. We're getting a bad habit this week of jumping down rabbit holes instead of sticking to the documents. Landlord consent required for certain things, so the tenant needs to understand that they have to have permission to make any changes or alterations to the property, meaning paint on the walls. Certain landlords are very particular about hanging pictures on the walls. So having a conversation about that with the landlord, having it in writing, is a very good idea. The tenant cannot rekey the locks or change the locks without having permission and then providing keys to the landlord. Insurance requirements. There is something that is commonly referred to as renter's insurance. So this is a requirement for the tenants to have insurance before they move in. I see sometimes in the additional terms that agents add, tenant to have renter's insurance. Well, it's already right in the lease that they have to have it. So you don't have to add that additional language. It's already right there. Cost enforcement waivers, exemptions. This is all the legal section right here that talks about how the landlord is reimbursed for, excuse me, any court costs and any compliance that they have to enforce for the tenant to actually maintain and honor the lease. So the landlord gets reimbursed, if they can collect it, obviously, from attorney's fees and court costs if they have to evict or file for judgment for the money that's owed. And they also can be reimbursed if the tenant has done anything to the property that needs to be fixed. This is the acceptance of rent with reservation detail section, if you want to read it later, that talks about how rent can be accepted with the appropriate documents. A partial rent can be accepted and still the eviction process can continue. The right of redemption in the state of Virginia is super important, because when an unlawful detainer case is heard and won, there is a redemption period where the judge says, okay, landlord, you win, you get possession and you get judgment for money in the case. And then there is a period of time where the tenant can say, I'm going to pay up. And if the tenant pays up, they get to stay. All right. So it's not just automatic as soon as you walk out of the courthouse that you get to go change the locks and carry the tenant stuff out to the curb. Access to the premises. This paragraph right here is where it talks about the landlord being able to come in and inspect the premises, to come in to do repairs and work to the home. It also talks about what happens when the landlord wants to sell the property towards the end of the lease term. So it says that the prospective buyers are allowed to come in 90 days prior to the end of the lease term with the landlord or designated representatives. So it's not up to the tenants to say, I'm not going to allow you to show the property. And the tenants can be considered in default if they don't allow the showings. Okay, so I want you guys to be very clear on that. Transfer of landlord and transfer of tenant. This is important. This is the only lease break piece that is part of our VRLTA statute. Transfer of landlord. If the landlord resides outside of this area, they can break the lease after 60 days notice given to the tenant if they are going to move back into the property. Okay, so if you have a property here and the landlord lives in California and they're coming back to the area because of their current landlord, right? Or I'm sorry, their current employer that they are employed with when they enter into this lease, they can break the lease. They can't just decide that they're going to quit their job in California and move back and break the lease. That's very different. Okay, it's all based off of the employer at the time that the lease was entered into. That's the same thing down here with transfer of tenant. So there's the Service Members Civil Relief Act, right, which is for our military members that, you know, if they get orders, right, we can't hold them to the lease, right? They get orders, they have to go. It's not their choice. Transfer of other tenants, if you check this box right here, what this means is that anyone who's not in the military has the right to terminate the lease if they are being transferred more than 50 miles from the property by the employer on their application, right? So by the employer they had at the time that they entered into this lease. And it explains what the penalties are for that down here. So it depends on how far into the lease term they are. If they've completed 6 months, then it's one penalty. If they are less than 6 months, it's another penalty. So that's the only term that's in there right now as far as any lease break ability. Landlord is unable to deliver possession of the premises to tenant. So what does that mean? Well, it means that they entered into a lease and that for a certain start date, and then something happened and they cannot actually move in. The tenant can't move in because there's something wrong with the property. So the landlord has to provide an alternative. Maybe they have to put them in a hotel. Maybe they have to do something, or the lease gets terminated. Bankruptcy, we're not really going to get into, but bankruptcy affects this because of the lien on the property. So bankruptcy for tenant or landlord, it could apply. Death of a tenant or landlord. So it's different depending on which side it's on. So sole or all tenants' deaths. Okay, so this means if it's one, if the tenant is just by themselves, or if everybody right, that's on the lease perishes. The lease is automatically terminated and rent due to the landlord. Rent is due through the end of the following month, right? So why is it automatically terminated? Well, the tenant can't pay. They've passed away. Death of one, but not all tenants means lease may be terminated by either party by giving 60-day written notice. I want to be clear though, tenants, when it says tenants, this means people on the lease. They have to be on the lease. If they're not on the lease, it doesn't apply. Landlords and tenants can make any agreements that they want, but it's not an automatic. Okay. Death of a landlord. Lease may be terminated by remaining landlord or estate by giving written notice of 2 months. So that's 60 days, but they don't have to. The estate can continue to be the landlord and allow it to go through the end of the term.
Shannon,
Yes.
is that tenant or landlord? The tenant is husband and he has family, but his husband have name for his lease, and husband is die, and his wife and family is still here. What happened this situation?
So in our lease, every person over the age of 18 should be on the lease. So if one of the adults passes away, then the other one is protected, right? Because they're still here. But if there's only one person on the lease and that one person passes away, it says right here that the lease is automatically terminated. So the occupants have to move out. Okay.
Okay.
All right. Fire or casualty damage. This actually comes in with the insurance paragraph. It has to do with repairs, and that it says that the tenant has to continue to pay rent during a period of where the repairs, if the repairs are occurring while, sorry, I don't want to confuse you guys. I'll start over. If the landlord determines that the damage does not render the premises substantially impaired, the tenant doesn't have to vacate. The landlord can repair everything and the tenant still has to pay. So even though it's been damaged and there's a part of the property that cannot be used, the tenant still has to pay the full rent each month is what this is saying, okay? If the premises are not inhabitable and the tenant has to move out, then the lease terminates. So there's no more lease at that point, right? The tenant moves out, no lease, they don't have to pay anything. Sale to tenant, all it says is that there's a different agreement that must be entered into. This doesn't have anything to do with sale to tenant. Move out inspection. Move out inspection will take place within 72 hours of tenant's departure, right? The tenant has the right to be there for that inspection. We talked about that with the security deposit. This is a brief checklist for our tenants of what has to be done prior to move out. Subordination means that the lease shall remain subject and subordinate to all mortgages and deeds of trust now and hereafter affecting the premises. That means that the lease is subject to the sale of the property. That's all that means. Okay, so the landlord sells the house to somebody else. The lease is still in place. Just the new owner is the landlord. Notices, all notices shall be in accordance with VRLTA. And this is how they'll be delivered, right? Similar to our other documents. Lead-based paint. This is a trigger like we talked about with listings yesterday. So there's a lead-based paint addendum in your packet. Looks very similar. Just says rentals on it. Statement of tenant rights and responsibilities. That is a requirement to all leases. Many of you have submitted leases to me that I have returned that say missing tenant rights and responsibilities. It is a requirement to be attached to this lease.
Is that to this lease only, or I'm thinking back to, because I'm renting from a private owner myself, and my contract didn't look anything like this, and there was never any like tenants' rights or responsibilities. So is that specific to this document only, or in general as a renter in Virginia?
It's pursuant to the statute and VRLTA. So it depends on what you entered into, and it went into effect July 1st, 2020. Okay, attachments. That paragraph doesn't mean anything for you guys. We've talked about everything in it. It's just restating. Attachments, assistance animal addendum, pet addendum, EPA booklet, statement rights and responsibilities, lead paint disclosure. You check the box if there's something attached. Discrimination. Fair housing, fair housing, fair housing. I encourage you, if you have not taken a fair housing class recently, familiarize yourself with all of the fair housing rules, all of the pitfalls. Statutory notice to the tenant. This is Megan's Law, right here, okay? It's in the lease as well as our agency agreement. It's all right there. You have to disclose whether there is a real estate licensed party involved in the transaction, and then you have a very small area where additional terms could be added if necessary. Okay.
What happens if, for the real estate parties, I signed my lease pretty recently after I was licensed, and I didn't see anything in the lease about this? Will that hurt me? Will that hurt them? Am I in trouble for not disclosing that?
Every realtor has to disclose that they are licensed. So you might want to do an addendum to your lease, but I don't know what your lease looks like, so I can't really speak to it.
Okay, cool.
I have a quick question.
Yes.
Regarding to the disclosure, if there is like a suicide happened in the premise, do we have to disclose it?
No.
But if they find out from neighbors or somebody, do we still have to disclose it or?
No.
No? All right, thank you.
You're welcome. This is your statement rights and responsibilities. I'm going to have Drew take over so that I can go to the forums committee meeting and hopefully not get in trouble for being late. And he's going to review the rest of the document. So you guys can take a 5-minute break while I switch Drew to the host, and you guys can come back and get into the rest of the documents. There are a couple of documents that are just here in your packet that we'll go over tomorrow because they're similar for contracts. And then you guys will go over statement of rights and responsibilities. You'll briefly review the agency agreement, so tenant agency agreement and listing agreement. And then you'll review the application. Right? And then you guys will be done for today. All right, so 5 minutes, 10:15, come back and give Drew as much attention as you guys have given me. Thank you.
Thanks, Shannon.
Thank you.
Thanks, guys.
Thank you.
All right, thanks, Shannon.
Thank you.
What am I going over again?
So you're gonna go over tenant rights and responsibilities.
Okay.
And the pet addendum.
Okay.
And then just briefly, the tenant agency agreement and the listing agreement.
No problem.
We've been over the regular ones already, so just the couple of pieces to point out that are different from what we went over. And then we will be good. You don't need to go over the lease, the addendum or the notice, because I'm going to go over those tomorrow. I just included them in the packet, but I'm going to go over how to write those tomorrow in the contract day.
Will you be back, or we won't see you again?
Yeah, I should be back.
Do you know what time?
What's that?
You know what time your meeting's over?
It's supposed to be 10 to 12, so I'm hoping that it won't go all the way to 12. I don't know how long these people talk.
Okay. You know I like to end class early, so
I know you do. Well, text me if you're going to end it early.
I will.
Okay, thanks.
Mhm.
And it's recording, so make sure that at the end you click off the recording.
Okay.
Thanks.
Take your time, guys.
While we're in a break, I do have a quick question. Just so I have my lease in my hand for my current, rental. It's just written on like 8x10. There's no fancy anything about it. There's no like statutes listed or anything. And some of the compared to the lease we're looking at now, some of this language is a little bit vague. It also stops on number 43, which is why I was asking about the real estate license parties. Like I never had a place to like check, yes I am, or no I'm not. Not that I feel fishy about this lease, but it seems a little, do they have to include all the, like, would they necessarily have to include?
Are you in an apartment or
I'm renting from a private owner.
private owner?
Yeah.
And they just kind of wrote their own lease?
I mean, it follows most of it. I'm trying to compare the numbers because it says like number 1 is premises, number 2 is lease term, but they only have 43 sections listed, and I'm trying to see where the differences are.
They may have had an old copy of the lease. That's all.
Okay. But even though it wasn't listed as a requirement for me to check off here, it would be recommended that I send them an addendum, like, hey, I'm an agent.
Not sure why you would have to. You were a licensed realtor when you signed this lease, or
Yeah.
you had not been licensed yet?
I signed this lease on November 7th.
Okay.
10th. So I was already licensed, but like I said, it never asked for it because I read the leases whenever I get them. I'm not just going to sign something.
Didn't ask for it.
Right. So I didn't know if that was something that by Virginia I had to disclose,
Drew.
ask for it, and I'm trying to protect my butt.
Samantha, it's Deb. You don't need to let them know. You're fine.
Okie dokie. Thank you, Deb.
Thank you for saying that while we were recording, because I didn't want to.
Cool. Thank you. Okay, uses.
Drew?
Yes,
Hey, guy, how you doing?
I'm doing fine. How are you?
Hey, congratulations on your new grandchild.
Thank you, man. Thank you.
I saw the post the other day.
Pretty cool stuff. My stepdaughter's an amazing woman. So super happy for her.
Yeah, great, man. Yeah, so just another one for you to spoil.
I don't know, man. I'm running out of dead presidents to spoil live children.
Yeah, I know that's right. Hey, man, I got 12, 13 grandchildren. Just set your budget, and the more you have, the less they get, but the budget stays the same.
Yeah, I told them on Christmas we'll just go on a vacation. It'd be cheaper.
For sure.
If you guys both have grandkids, then you are older than I am, whether I am chronologically older than you or not. Man.
Yeah. Well, I'm probably pretty old.
Me too.
I thought Drew was younger than I am, but now I'm convinced he's much older.
Just don't tell anyone.
He's an old soul.
That's right.
It's all the beauty products to help him look young.
That's right. Hey, Deb Roof.
Yes, sir.
How you doing?
I'm doing good. We're recovering.
You wanna
We're getting stronger.
make us both feel a little older. Kiara had her baby.
That's what I just heard. I can't
Yep.
believe it.
Yep. Insane. Who knew?
Congratulations.
Thank you. Is everybody back, man? Let me look at the screen.
43 people are back.
It looks like maybe I'll wait another couple minutes before we go through this. I'm glad Shannon reminded me that we are recording this, so I don't mention how boring this stuff is.
You can always pause record.
Yep.
Hey, Drew, did you say you just had a baby?
Not me, my stepdaughter.
Oh, okay, cool. Grandfather, cool.
Yep. Super cool, super cool. Beautiful baby too.
Right on.
I'm super happy. All right, guys. So I'm just gonna just give me a couple ahas from what Shannon went through. I just want to see if everybody was paying attention. Remember that some of this stuff it's long and it can get boring. I have a saying that he or she that knows the contract always wins. And so it makes sense to know these things in case you ever have to have a heated debate with someone about those things. And Shannon does a great job of breaking it down into language that, dummies like me can understand, right? Whenever I need real estate for dummies, I just call Shannon and she puts it in terms I can understand because, I'm a little bit, we won't go there. So today I want to make sure that you understand the agreement that goes into place when you're going to help a tenant, right? And I'm just going off of the documents that Shannon sent me, but we all have filled one of these exclusive right to represent tenants out, if you've had a career longer than a couple months, and we have all had pushback from the tenant to sign it. They don't want to commit, right? And I need you guys to understand, and this is not part of what Shannon wanted me to talk to you about, but I want to talk to you about it anyway, is if you make the agreement a big deal, it shows, and then they make it a big deal. Anyone who's ever sat in my buyer presentation knows that when I slide over the buyer agreement to the buyer, I make it about as nonchalant as it can be. And to be 100% transparent and clear, these agreements for to represent the tenant and to represent the buyer, they're really not worth the paper they're written on. A buyer could get out of either one of those at any time. So don't make a big deal out of it when the time comes to get this signed, right? And there's a couple ways that I like to do that with both of these. One is bring a copy with you on the first showing if they're giving you grief about signing it online or during your Zoom appointment. Bring a copy with you that's signed. That's filled in, sorry, not signed, that's filled in. Put an X where they need to initial. When you pull up to the home, before you take them in, either a tenant or a buyer say, hey, listen, this is an agreement that we have to have in order for me to show you homes. But I tell you what, initial it here, initial here, sign here, and then I'm gonna let you hold it. And at the end of this, if we decide that we want to work together, then you can give it back to me and I'll have my broker sign it. You still have a signed agreement. You're still CYA. We all know what CYA is, right? If you don't, raise your hand.
CYA?
Cover your. Yep. Okay. Don't make a big deal out of it. So if it was me and I'm taking Raekwon out to see a home and say, hey, Raekwon, listen, this is an agreement we got to have in order for me to take you in this front door. I've put an X next to where you need to initial and an X where you need to sign here. Let's do it real quick. And when you're done, I'm going to let you keep it. And at the end of this showing, if I decide I want to work with you and you decide you want to work with me, you can give it back to me. I'll get my broker to sign it and we'll make it official. Okay.
Just to clarify though, so it does not need to be signed by the broker before the showing.
100% it does. 100% it should be. But we all know, and listen, Shannon's probably going to kill me for this. We all live in the real world where there are people that will not sign it, period. There are commitment phobes out there, right? Right? And we have to find a way around it. And I'm probably going to get yelled at, but that's okay because I do live in the real world and I still do work with buyers, right? Any buyer that I don't have a previous relationship with gives me a grief about the agreement. Every single one. And so I've come up with this way to do it as well. Now, if you want to do it by the exact rules, you could say, we'll sign it online. I'll have my broker sign it and I'll bring it to you. And at the end of the day, if you're not happy with me, we'll rip it up. Okay. At the end of each presentation, whether it's for a tenant or a buyer, I slide it over and say, hey, sign this, and then we'll get started. And as soon as I slide it over and I hand them the pen, I start talking about something else.
Mm-hmm.
So if it was a buyer, I would say, or even a tenant, when I slide it over, here, sign this. This is what we need to get started. And by the way, what are good times that you think we could go start seeing homes? Do afternoons work better? Evenings, weekends, right? So I'm deflecting the fact that this is an agreement, and because it's not a big deal to me, it doesn't become a big deal to them. All right, and that's my rabbit hole. Let me share my screen and continue with going over these documents here.
Well, in some cases, Drew, I'm sorry.
That's okay.
Is somebody talking?
Yeah, you go ahead. I'll go after.
Okay. In some cases, we find out rather quickly that somebody needs to go see a rental property, and we just take the form with us, fill it in, and get them to sign it there. Is there any other form we need to take with us, or is that just in those cases?
You mean when you basically, you've got the standard forms that are in the template that all need to be signed. In order to CYA, you need the exclusive right to represent tenant agreement signed. But technically, it's not enforceable or even really any good till Shannon, your broker, signs it.
Okay.
But you can, if you bring them with you, it's still, you have a commitment that you can bring back to Shannon and say, hey, I kind of jumped the gun here, right? I'd always ask for forgiveness instead of permission. But don't listen to me. What do I know?
No,
About this.
Yeah, sometimes they just say, well, somebody wants to see this property, and then you're grabbing it and going.
Yeah, well, listen, I don't know about you, but I'm not a nonprofit organization. I do this to get paid, right? We do this to make money. And if you show someone something for free and then they walk out the door and say, thanks, I'll have my realtor call you with an application, how would you feel?
That's right. But you don't let them take that home with them, right? You take it,
No, I take it back. I take it back and I'll upload it into Command and have Shannon initial it.
So you give it to them, show them the unit. Then when you're walking out the door, you say, okay, how do you get it back from them?
Well, so that's a great question, Richard, and I'm glad you asked. So Richard, we saw this property. You know, I'm interested in working with you. Are you interested in continuing this relationship so we can help you find that home? Absolutely. Well, here, give me that back. What I'm going to do is I'm going to have my broker sign it, and then I'll send you a copy right over to your email.
Got it. All right, cool. I've been dealing with this for a while now. Thanks.
Yeah, listen, you don't make a stink of it.
Right.
Right. Don't make a stink of it. And like I said, honestly, they could get out of it in 6 seconds if they wanted to.
Mm-hmm.
So we make a stink out of it and we get ourselves all puckered up, right? Because are they going to sign the agreement? Are they going to sign the agreement? Take that out of it and watch how much you stop projecting that on people and they loosen up.
Is it acceptable to say something like, this is a formality before we see some homes? I need to have, we sign this together. It protects you, it protects me. It's not a marriage proposal. High five, put your name down.
Yeah.
Cool.
Yeah. And sometimes even doing that scares people because you sound like hey, this is the agreement for us to work together. I put an X where you need to sign. By the way, what's a good time for you to see homes?
Mm-hmm, mm-hmm.
You see how no big deal, on to the next thing. Even in my buyer's presentation, do the same thing.
Is it normal to get a client without a true buyer's presentation? I asked because I've been talking to a guy and he and I are planning to sign the agreement tomorrow. He was like, I'm easy. You got some houses for me? I'm like, yeah, I do. And he's like, okay, let's go.
Okay. Now, I'm glad you asked that. Yes, it is easy to get one. It's also easy for the client to have 1,000,000,100 questions while you're doing it. Because remember, our buyer presentation is not only to show our value, but it's to educate the client.
Yeah, I told him that I would send him, like, so when we go over the contract, or the agreement will be the last thing I show him, but I plan to go through it, but not give him the full, like, let's talk about what you want, because I already have all his information. But giving him like a glossary or a timeline or stuff to, break it down. That's
so, hey, like Sam, hey, I know you guys have already decided to work with me. Do you mind if I spend about 10 or 15 minutes going over the home buying process? That way, once we hit the field and we're out there looking, there'll be, we can minimize the surprises.
I dig it.
I have an input here. I think that the very good thermometer of how the buyer presentation goes is when there are no problems about signing. Just the form is just one more thing to do. I think that at the end of your buyer presentation, you said, okay, let's just practice how the electronic signature is gonna go with the exclusive right to represent.
Yep.
They won't have any problem. I think that it's something that you deserve. It's nothing that you have to be sneaky on.
No.
It's something that you deserve. It's part of Virginia law. Have to be signed. In my case, there are no way that I'm going to show in house if they don't sign the exclusive right. That's it.
You're not supposed to, number one, and number two, there are agents that do it. One of our competitors, right, Redfin, will show a house to anyone, anywhere, at any time, like Uber. They just meet you there and let you in, right? So we're held to a higher standard. And so I say, if you don't make a big deal out of it and you just tell them to sign, and that includes the tenant agreement, right? I mean, if someone calls and you have no idea who these people are, and they call the office and somebody hands it to you and says, hey, they want to rent a place, call them, and you call them and you're like, hi, I'm Drew Sorsky, I'm your guy, sign here. They're like, no chance, right? I just found you, like, I don't know you, right? Who are you? So it takes, you have to work your way up to that. And some people aren't. So that's why I found the way that I'll bring it with me. We'll sign it, you hold it, kind of works for those stranger danger, right? Okay, so let me not go down too many rabbit holes. Any other questions before I start? Okay, let me share my screen and go over this exciting exclusive right to represent tenant agreement. Put your seatbelts on, man, and hold your applause. The excitement begins.
Strap in.
All right, let me make it so I can see some of your smiling faces. Okay, you guys have gone over the buyer agreement with Shannon, right? This is very similar. And it just starts out with the date, of course, right? The tenant's name, and then of course, KW United, right? This is an agreement between them and KW United, not you, right? And so number one is they're appointing the broker, right? That means you're agreeing that the broker is going to be the person to represent you, okay? And then number two basically represents that the broker is going to give you any properties, and then anything you do, this person represents you, right? It also says that they seek to lease a property. Nothing hidden in there, right? No crazy language. This is for notices, man. Back in my day, when I first started, we had to fax things or deliver things to people. And so this has remained the same over the years, as the notices. How will we deliver the notices? If it is something that is a hard copy, who do we take it to? Right? And so this will be, you'll put their mailing address and as much information as you can. And then your brokerage, whichever one you're in, Fredericksburg, Kingstown, Falls Church, you'll put that. Now she's told you what email to put, right? On this form and this part of the form. Which email is that?
For us, it would be KW Agents Falls Church.
One for the brokerage.
Thank you. Thank you very much. Okay, so number 4 is the term. Okay, now this is where you get a lot of pushback if you make the term too long. If it's a rental, gauge the comfort zone, gauge what you've talked to them about. I don't like to do less than 3 months. And I'll tell you why. If you're helping someone now find a rental and it's January and they want to move in March 1 and you start helping them now look for places that you're going to apply for, you just got to make sure you protect yourself. So I don't like to do less than 3 months, right? If you can get more, I always say, you know, be safe and put more. Okay. This goes over the brokerage duties here. You guys should all read that. I'm not going to read it out loud to you. You have this in front of you when the time comes. It just basically says what you're going to do, right? As far as when we go back up to 4, sorry, I missed the early termination fee. I don't put anything there. By the way, Deb Roof, if you have anything to add at any time, just chime in. Thank you. I don't put anything here. If you put a number in there, it scares people off as well. So I don't.
Is it better to leave it blank or to put 0?
I put 0.
Okay.
I'm anti-blank. Growing up from the Deb Roof School of Contract Writing, back when I was a young pup, we didn't like blanks. If you can put something there, we always put something there. If you can't, it's okay. But for like 0, or if you're not going to charge someone something, I always put 0. All right, so number 6. Number 6 is very important because of this first line here, right? And when I go over the agreement with someone, I usually only read this first line when I'm working with a tenant, right? So just to let you know, I have my duties here, right? And the first sentence is I'll promote the interest of the tenant. And then when I go to number 6, I always say, and I read the first sentence. Okay. You want them to know that this is an exclusive relationship. Tenant shall work exclusively with broker during the term of this agreement. Okay. Purpose. For purpose, we put residential. Residential lease, residential, whatever you want to put. It should say residential. Now, some charge a retainer fee. I have charged a retainer fee before. I would charge a retainer fee after I've shown 5 listings to this person, because I'm already knee deep into it. I've already bust my behind for them, and they keep saying, oh, well, maybe we'll find something different. After you've shown 5 rentals, you've spent enough on time and gas that you're probably going to break even on the deal anyway. You don't have to. I do.
Drew, what's your standard practice? How, roughly, what kind of retainer are you charging?
$150 to $200, depending on a monthly rent.
Thank you.
Mm-hmm. Now,
Drew, do you do that at the time you're doing this agreement so that you can show them the?
Yep. So I will put it that I will say 200. I'll put 200 in here and say it shall be subtracted. And then I'll put after 5. Now I know I'm not supposed to. It'll go into the other terms, and I'll show you that when we get down to the bottom. Now, what does that do? 2 things. Sets an expectation of how many properties it should take for us to find them something. This ain't rocket science, people. If we get an idea of what you want, we'll find you something within the first 5 usually. After that, there's a retainer fee required. Okay, so for compensation, this one always throws people off, right? Because it says tenant shall pay compensation of blank amount. Does anyone have an idea of what goes there?
25% of the first month's rent.
Yep.
Now it does, but if you were a tenant and you didn't do this every day and you read that first sentence, you would think that you pay that, right? So give me some ideas that you guys have as to how we can make that so it's not scary to a client or scary to your potential tenant that they think they're going to have to pay that.
I don't know. You put 0 in there? Can you put 0?
Shannon, would flip if you did. Now, you
Would you read
can.
the next line?
Yeah, thank you. Who said that?
Your
Alicia.
star student. Your star student.
You're the GOAT. You are the GOAT. Right there. So if you want, you could put 25% of the first month's rent, which is the minimum you're willing to take, that goes there. For me, if I have a frustrating tenant, I will put in parentheses, paid by broker next to it. Just to, and I know it says it here, but I will reinforce and I will let them know that I will, whatever the broker's taking, I mean, whatever the other broker is paying, I will accept. If you want to make sure that you get at least 25% and you go to some random place that's not paying 25%, you may charge them the rest. But always read that next sentence to them. Okay. For number one, for me, I put 30 days. Okay. So if within 30 days after expiration or termination of this agreement, tenant enters into lease for real property, right? I want to get paid. Never had to use it. That's what I put. And number two, right? If having entered into a lease for real property during the term of this agreement, tenant defaults under the term of that lease. Now, in addition to the broker's fee, right? I'm not a fan of this. You can put, if there's an admin fee, right? If you guys have an admin fee there that you're going to charge that tenant, you can put that there. If you have an admin fee and don't have an admin, shame on you. Moving on. If they're part of a relocation program, you could check yes or no. That's self-explanatory. This is legalese that they put in there so you understand. So before we used to have to explain to people what designated rep was, right? What tenant rep was. They put the definitions in here for you. So they call it disclose and informed consent, which means you know each person's role. By signing this agreement, you understand what the role is for the tenant representation and you understand what designated is. In my opinion, you always want them to consent to designated. Always. I don't know if anybody said don't, but I say do. On a tenant agreement, I would say you want them to consent to dual as well. Now, I know Shannon may not agree with me, but you could always pass it off to somebody else if it becomes a conflict of interest. But with a lease, there's not, if you have a property for lease and the client loves it, why not? Fair housing, everyone should make sure they're up to speed on their fair housing. Don't put your foot in your mouth and don't go to realtor jail for saying something or doing something stupid with that.
Well, let me ask you this. Why would Shannon disagree with you on the dual?
Newer agents that are mostly on this call may not have the necessary experience to handle both sides of a transaction. And it can be a conflict of interest if you're advising two people, right? You're negotiating against yourself. So with a tenant, like I said, it's different. I'm sure Shannon has a different stance. She may not be as opposed to it as she is on a purchase. This explains attorney's fees if something happens, yada, yada. The tenant does not hold an active real estate license.
May I ask a question on that?
Please do.
Okay, so say a tenant enters into the lease with no real estate license and then they get a real estate license. Do you need to change something?
Nope,
Okay.
nope, you're out. You're out after that. So other provisions, oh man, might get in trouble, but here's where I write, after the first 5 homes, a refundable deposit of whatever is due here. That's where I put that. I would, in the beginning with the newer agents, I wouldn't put that. I would just build your database by helping renters and stay in touch with them throughout the year and convert them into buyers.
So Drew, you would do, say the wording again, and you're doing a refundable deposit. So if you help them find the rental and you get paid, you give them that money back. Okay, got it.
Now, I like to do that in the beginning because I just want to set an expectation, right? Look, let's just be real with each other. You don't make a ton of money on a rental unless you're like Melinda and you get to rent a house that belonged to a Washington Wizard and you get to rent it to a guy who plays on the Washington Nationals, and the rent's like 10 grand a month, right? So you don't make a ton of money doing these. And the more you show rentals to people, to the same person, the less profit you end up making, right? And it can be just as much work, if not sometimes more, than a sale. And you bust your butt for $100 and then you say, well, I spent $20 in gas and then I spent 5 hours helping them. My time's worth $20 an hour. I'm negative $20 in this deal. Right? Now, when you see the bigger picture for the newer agents, you get a ton of experience. You learn how to open a central lock. You learn how to schedule showings, right? So you offset that. You also potentially build a referral network. You do a good job for that person. They start referring you more people. They even may refer you a buyer, or you may sell them a home in a year, right? Remember, this is a marathon, not a sprint. You guys all know how to fill this out, right? That's your name goes there, by the way. If you know how to spell your own name, you put it there. If you're on a team, you can put it there. You put your phone number, your cell, your email. Then down here, you put Shannon. And you put her email. All right. Oh boy. This is going to be fun, guys, so bear with me. This is a standard rental application that Shannon gets from NVAR. You will find that not all rental applications are like this. Okay. Some property managers, some landlords have their own. Right? Now, when you get to this point, you can, if you're doing a consultation with a potential renter, you can go over this with them ahead of time if you want. It's not a bad thing to do so in case you take them to a rental that has an online version of this application and they have to fill it out on their own at home. So you've kind of already gone over this with them. Now, we all know that you are not supposed to technically ask people like about their credit. You can in a way, but you don't say, what's your credit score, right? Now, using this application in the beginning, you can get an idea you can ask them for an idea of what their credit score is, right? And so the rental application is an offer to rent. The lease is a legally binding contract. Okay. Now here's where it tells you what the protected classes are. See that? You can mention that to them. Now, the brokerage disclosure. When you're going over this with them, you want to tell them to put KW United here. Oh no, I'm sorry. The first one is whoever's representing the landlord, right? Then the second one is the leasing broker. So on the application, your clients are filling out this to lease the property. That's where they'll put the KW United. And then they check that they represent the tenant, and then they'll initial here. Okay. They want you can get them to attach a business card to it. That's where it says you must attach a business card.
You can ask a question.
Yes.
So when it happened that I sent through DocuSign, right? And when I sent to DocuSign to let them finish to fill up, I always put the part that, you know, is I can fill, and after I send. Is okay like that?
Yes. If you're willing to add the text box, yes.
Mm-hmm. Okay.
Here's where they just put their name, right? And then the application fee is usually listed on the listing. Okay. And so that's where you put a non-refundable processing fee, right? And make sure when you're going over this with them, this gives you the in to let them know that the processing fee is not refundable. Does that mean that they don't always, that property managers don't always give the person that money back? Sometimes they do. I've seen it happen, right? But you let them know. Okay, so they say earnest money deposit, right? That's your first month. I mean, security deposit and or first month, same, you know, two different things, but whichever one you want. They're usually the same number, right? To be held by. It's been so long since I've done one of these things. Shannon really picked the wrong person to explain this, but to be held by, of course, you're going to put the landlord's agent or if there's a property manager listed, right? Applicant.
Sorry, because what I understand what she said before is the first month, the earnest money deposit, you give as a first, you give the monthly rent and you give it to the broker. And after you give it the earnest money deposit, right?
Yeah, so you're giving, this is the deposit that on this application, they're calling it earnest money deposit. It could be considered first month's rent.
Yeah, exactly. So in this case, it will be held by KW.
Yeah, so you,
because if you think about application, we need to send the first money, the first month rent. So in this case, it should be held by KW United.
no, it's, you know, we don't hold anything. Not when we're representing the tenant. Deb, if I'm wrong, help me out here, but.
No.
You're right.
No, okay, guys.
The agent,
Listen,
No, I
the-
think it should
the
be
property
to
manager
KW.
company will hold it.
Yeah.
No.
Okay,
Property
let me
manager company.
speak. Can I speak?
Go for it, Deb.
Okay, everyone. The first month's rent is the commission by which the listing agent and the tenant's agent get paid. It is paid to either the listing agent's brokerage or a property management company, depending on what the listing online directs you to do.
Right. Thank you.
Plain and simple, period.
Yep.
The security deposit, which is a different issue, that goes directly to the landlord before move-in.
So indeed, so when they say here is included and will be held by, what do you need to put, landlord or our broker?
No, you put the listing brokerage or the property manager, depending on the instructions on the listing. Not us. We are not, you are representing the tenant. We are not holding that money. That will be held by, and like Deb says, that is used to pay the commission for listing and tenant rep.
Okay. I'm a little bit confused by it. Okay.
That's okay. So here's how to unconfuse that, right? Where it says held by, put listing broker or property manager. And you'll always remember that. Not us.
Okay. So the check go to the listing broker. I've never done this. Go to the listing broker, and the listing broker of the is going to give it to our broker that is going to pay me.
No, the listing broker is going to take their share first and then
Yeah.
mail a check for the rest.
Never done this.
Yeah, so the listing brokerage will deposit that check and then issue a check from the listing brokerage's name and mail it here with the address on it. And then the MCA figures out how to pay you. Contact information is self-explanatory. Office use, we don't need to use that. Here is where you can run over your clients. Hey, when we start going to see rentals, this is what I'm going to need. Let's get that together before we start going. Right? Easy peasy. Number 4 is you say, hey, let's get this all lined up, right? Have it ready to go in case we like something. We can pull the trigger pretty quickly.
Okay, question though, when it says latest pay stubs, about how many, 2 or 3 or 4?
So that depends on the property manager. I've seen property managers want a month worth, and I've seen property managers okay with 1. So I would just say, you know, if you can get a couple pay stubs to be safe, right?
Okay, thank you.
Of course. Just make sure you understand this. May rescind acceptance and resume marketing until the lease is signed. So you get a client, you take them out to see the place. They love it. They put in there, they write their checks, they get approved, and then they sit on the lease for 2, 3, 4 days. The landlord and the listing broker can continue to accept applications. And if your clients don't sign right away, they can accept another application. And so your client's dragging their feet on signing the lease or say, hey, we'll look at it when we can. If you don't notify them of number 3, they could sign the lease and send it back to you. And you could call the listing agent and say, yeah, we got tired of waiting. We got a better offer. So this is important to educate your clients on this as well, because again, you showed them 10 places, they wrote the application, they paid the non-refundable application fee, and then bam, they drug their feet on signing the lease and somebody else snuck in. Let me check the chat. If the lease is under a property management company, they may have their own application process. Yep. Thank you, Young. You're absolutely right. They could have an online application. They could have an application that says, do you want to live here? Check 1. And that's it. Like, they could do whatever they want, but this is the standard safe application.
So is it our responsibility to complete this rental application for them?
Negative.
Okay.
You can, if you'd like. I don't. And I let them know at the consult, I'm going to be sending you the application from either NVAR, which is a standard application, or you're going to be applying online, or I'm going to send you an application from that is for that property management company. Here's what you do. You fill it out, send it back, and you also need $50 per person that you're going to apply. And by the way, that's anyone over 18 that lives on the property needs to be on the application. And that's $50 per person. If you roll through these, applicants agree and understand that. When we're done today and you have some free time later, look over these, right? Because it kind of tells you what Shannon was talking about. You're going to need 2 forms of ID to sign the lease. Valid forms mean government issue, military ID, driver's license, all that jazz. Let them know that they're going to have to get these. Some people don't know they have to have insurance. I think Shannon was touching on that. It lets them know here, right? So if you go over the application with them, it's going to reinforce what Shannon told you to tell them earlier. This one's a doozy right here, folks. Make sure you cover this with them and make sure every listing that they like, you read the agent notes. You read through and make sure there are no move-in fees or anything like that. Because there are, and an agent will sneak them in in the listing. Now, if the reason that I say you should check this, and also be careful how many listings you send someone. If you send someone 50 things that meet their criteria to rent, are you going to be able to read all those agent notes? Maybe not. Everyone that they like and send back to you and say they like this one, I encourage you to always read the agent notes and always look for for move-in fees. Sometimes there are 2 move-in fees. There's a move-in fee and then there's an elevator fee. Right? Now, nothing will make your client angrier than if they like something, they do the application, they get approved, and then you go back to them and say, oh, I missed this, but there's a move-in fee of $300 and an elevator fee of $75. How many of you think going over this during the consult will also help you remember what to tell your client? Especially the newer agents, right? You don't know.
Sorry.
Don't apologize.
If they say the renter insurance, it happened that they say, no, I never had, no one asked to me. What number do you answer?
That no one told you about, hold on, ask
No.
the question again.
So if I said to the client, do you have, the renter insurance? And they say, never, no one asked me this before.
Yeah.
What do I should say?
Well, you haven't signed the lease yet, so you don't have to have it right now. When you sign the lease, you will have to have some sort of renter's insurance. I have a great company I can refer to you. Here they are.
And do you know how much normally it costs?
Nope. It depends on the size, the unit, where it is, and everything else.
Thank you.
It's not that expensive, right? But if your client says, well, why do I need that? You could say, well, you're living in a building with other people, and if the building burns down, all your stuff is not protected unless you have renter's insurance. Right? If you don't have renter's insurance and you rent, you should have some. It's not
It
that
is a
expensive.
requirement under the lease.
Yes. Deb can back me up on this. I have had some landlords request a copy of it before they will let you move in. Not all, some.
Absolutely. Absolutely.
I have a rental property, and I ask my clients to send me a copy of their renter's insurance quarterly. I make sure that they pay it, right? Because they could get it and then just let it lapse and not pay it. So I one of my rental properties, when they renew when they make their payment every quarter, I have them send me a copy of it. Okay, here we go with this one. See number 11? This is important. I had a tenant who rented a huge house in Alexandria. And the reason she wanted to have a gigantic basement that walked out was because she does hair, and she was going to put her hair salon in the basement. She didn't tell me. She didn't let the landlord know, and she just did it. I couldn't figure out why she needed such a big space just for her and 2 other people, but I didn't argue with her. Had I gone over this is when I first started. I was at Weichert, black and yellow, so I was new. If I would have gone over this with her ahead of time, I would have known to ask this question. The landlord told her she wasn't allowed to do that because they didn't want the extra traffic going up and down the street. So she was stuck in a lease for a year and could not run her hair salon out of it. Any questions? Anyone starting to see why it may be important to go over this part during the consult? Sort of. Sort of.
I mean, I think it's a great tool just to prepare everybody of what to expect. So that once you actually locate a property and it's time to submit an application, everybody already knows what to do, what they need, and it's just smoother.
Yeah, and guess what? they'll sign the lease quickly because you've gone over it with them and no one can sneak in and steal it from you.
Exactly.
Right? This one's just important to explain to your client. Sometimes you'll have a client that'll say, hey, can I start moving my stuff in now, even though the lease isn't signed or anything, right? Until you just got to let them know you can't do anything until the lease is signed. This just means you agree to all the conditions here. Now, the reason that I stay away from doing clients' applications is because of they need their social security number here and things like that. So I let them know, fill this out completely, right? Reason for moving, not a necessity. If you have more than one applicant, if you have more than 3 applicants, you have to print an extra part of this page. Whatever page, this is whatever page 2 of 4. And you'll have to print another one of these if you have 3 applicants. They're going to want to know if they rented previously, they're going to want to know who they rented from. Make sure your clients have that info handy. All their income, any debt they have. Some landlords don't confirm this debt. Some do. You'll need to print a second portion of this, of page 3, of page 2, page 3, and page 4 if you have 3 applicants. And they'll need to fill all of this in.
Even page 1.
Yep. Next of kin, self-explanatory. The rest of this is self-explanatory. So we made it through this in less than 2 hours. Shannon is supposed to come back at 12, and we are through it. Is there anything?
She wanted you to.
Go ahead, Deb.
I think she wanted you to go over the tenant rights sheet.
Okay.
Didn't she say that?
She did, and then she didn't give it to me. So let me track it down. I'm going to unshare and.
Okay.
Drew, you said she's coming back at noon. Doesn't this end at noon?
Yep, I think she wanted to try to pop back in before it ended.
Okay.
I ran through it pretty quickly, so I'm going to go over the tenant rights sheet. I'm going to track it down real quick. Give me a second. If you have any questions, ask them while I look for it.
Okay, what about the exclusive right to lease the for the lease part, if you're the listing agent for the.
Okay, let me see if she sent me that one too. Give me a second. If you have any questions, shout them out while I'm looking.
I also mentioned the pet addendum, and there's a couple of other addendums that go beyond that as well. Just
all right, I found the tenant rights, so we can go through that portion and then acknowledge receipt. I got it. Okay. And then the pet addendum is under that. We can go over that. And then hopefully she'll be back to go over the rest. If not, we'll go over it. But let's start. My apologies. I was unprepared for class.
Drew, do you know if this Virginia statement of tenant rights and responsibility, is that a new, I see the July 2020, I haven't done a rental in a while. Is this a standard document that's on the, that's in the DocuSign or in command? And then take, okay.
Should be. If not, we can have it put in.
It is. It is.
So,
Okay.
Anya, I'm with you. I haven't done a rental since I was at Weichert. So this is all new to me. So yeah, it's in there, according to
Thank you.
Deborah. If it's not, blame her. Okay. So this is just the tenant rights and responsibilities, right? And the way they describe what it is in the blue box there, It's a summary of tenant rights and responsibility under the Virginia Residential Landlord and Tenant Act. This summary does not modify your lease or Virginia law, right? But it also says a lease cannot give up a tenant's rights under the law. So if something in there that is a handwritten lease doesn't trump this, right? And this, again, this information is not for legal advice. They got to lead with that. So let's just start through some of these, right? The application lets them know that the fee can't be more than $50. Okay, per person, per applicant. Now it says here, right? If the tenant doesn't rent the unit, application deposit must be returned. Now, didn't we just see on the application that it's a non-refundable? So which one do you think wins?
First one, not this one.
But it says application deposit.
Yep.
So it's about the deposit.
Yep. So you get your deposit back, but it's just a gray area, right? So you have to be able to explain this. Non-refundable application fee here. And then they keep reading and they're like, refundable application deposit. You have to distinguish between the two here when you're going over this, right? Yessie, great job. This is that check that we talked about with Veronica, who gets. In my opinion, when they wrote this, these should be two separate things, right? This should be in bold under this. It should say deposit, refundable, right? Because it's very confusing. All of us just now, that when I read that, we're confused. They're not distinguishing between the two. So you, when you explain this to your client, need to distinguish between the two. This is the application fee, non-refundable. In this sentence, they're referring to the EMD or security deposit or first month's rent, however your property manager, listing agent refers to it. So when you're explaining this, you need to explain the difference, because someone who doesn't do this every day, doesn't have a Deb Roof or a Shannon in their life, doesn't know what this is. Written lease. Got to have a written lease. We're not going to go off a verbal agreement. Disclosure. Right? Same thing as a depot. They need to disclose if there's mold. They need to disclose if one false move and the roof will fall off, right? They need to disclose those latent defects. Security deposit. See how it goes here? This, in my opinion, and I'm nobody, this portion should be here. A landlord may require a security deposit. Now, they may require 2 months rent. First and last, back in my day, is what they used to call it. This part talks about, it's this gray area. Tenant has the right to object to anything in the move-in report. Then move out inspection. Right? You got to let them know about this. 72 hours to get the inspection back to the client. Receipt. Just tell them that they have to request a receipt for their rent if they want one. Unless it's paid online, they automatically get one. If you're mailing off a check to a landlord and he only owns one property, he may not give you a receipt. So if you want a receipt, you got to ask them in the beginning. This just protects their privacy. A landlord may not release information about the tenant except under certain conditions. This is all common sense stuff here, right? This just means your landlord can't be a slumlord. You have the right to heat. If your heat doesn't work, you can complain. Repair and deduct. Let's say a tenant has to repair the heater themselves. This gives them the right to deduct it from the rent with permission, but also shows licensed contractor. May not be more than $1,500 or 1 month's rent, whichever is more. Eviction, we all know that no one's getting evicted right now. She went over the redemption, pay and stay, right? A judge can order that. Shannon went over that. Here are the tenant responsibilities, right? Got to pay your rent. Late fee. If you see here, a late fee cannot be more than 10% of the monthly rent. I have seen landlords try to make it more and hope you don't know. Required to have insurance. We sort of been over all of these. This is always a good document to have, to give to your tenant ahead of time. Maybe they can take it home, and if they can't sleep at night, read it. It'll help them fall asleep. This is a problem for me because it says a tenant may have to pay renter's insurance. Now a tenant is required by, I'm going to say 99% of landlords require you to. I haven't seen one that doesn't require you to have it. Access, this is something very important that you need to explain to your tenant. They have rights. The landlord just can't walk in and out without notice. They have rights, but they also need to understand that the landlord has rights as well to come when he gives you notice, right? And here it says 24 hours notice. Maintain fit and habitable premises. Again, can't be a slumlord. Keep everything up to code. Fair housing, we know that. They added the COVID-19 relief. This just means if you've rented something and you lost your job due to COVID, they can't throw you out. I have Deb, if you can help me out on this. I've never had a tenant sign one of these with a landlord when I've done a rental application. Okay. No problem. Don't know if anyone's done it.
Do we give them this at the time of the right to represent agreement, or is this done when they are doing the application or the lease?
Excellent question. Don't know.
I believe this is due when they're signing the lease because they want to know of their rights or responsibilities. When you read this, an
Makes
acceptance.
Well, that's
with
what I would
section.
assume, but I'm
Correct. It's part of the lease.
the lease. Thank you, Deb.
Deb, what do you put on that page 3 right there where it says acknowledgement of receipt of statement? What goes on those lines? Dwelling known as, is that the premises address? No, what is this?
What are you looking at? I can't see.
Drew, can you scroll up one on page 3? Just scroll up a little bit more. There we go. It's right there in those 3 lines. What goes in there?
Okay, let's see.
Address. That's where the address
Right.
goes.
Right, the address goes there, right?
Yeah. What I was asking Deb when you was I haven't done a lease in a while, but I've never had a landlord or a tenant sign this and exchange it with each other. Is it new?
Well, it says July.
Yeah, this is all new. Yeah, since July. Right, this is all new since July. So yes, during the lease process is when all this gets signed. Yeah, okay. Thank you for teaching, Drew. I'm still having issues reading, so I appreciate it. Thank you.
You know that it's anything for you, Deb. You know that.
Oh, sorry, I have a question. So this comes with the lease, but does this come from the listing agent or from the tenant agent?
Listing agent.
Okay, okay, great.
And
When you
again,
come put the lease together, it's just part of the package.
Okay, perfect. Thank you.
and again, remember that not everybody works at a great brokerage like you do. And sometimes their forms aren't updated. So it may behoove you to, if you don't see one, to add one, right?
Okay.
Absolutely. Absolutely.
EYA is the way I run my life and my business all the time. Pet addendum is self-explanatory. If you have a pet, the only thing I will say is the landlord gets to decide what that deposit is. This is the one thing. Deb, you guys give me a second. My son's calling me. I got to take it. Just 1 second. Hey, buddy. What's up?
Hey, Veronica, I sent you a message about cost of insurance because I know you were asking about it. So I shared with you what mine cost. So
Thank you.
Hi, Deb. This is the question with pets. There are no restrictions in Virginia as to breeds, correct?
It depends on the landlord. The landlord can restrict whatever they want to.
Okay.
I've had landlords who say dogs only. They abhor cats. So there's no protected pet class. And then there's neighborhoods who have restrictions. So you always want to find out, especially if there's a condo or an HOA involved, what are the restrictions?
Okay, great. Thanks.
Totally apologize for that. I'm having some work done on my house and my son had to call me to make sure he pointed them in the right direction. I knew it was coming too. Sorry. Okay, pet addendum. You okay, Deb? Oh, okay. Pet addendum. If a property allows pets, they will let you know on the listing what the pet deposit is. That's not regulated though. This is the one thing that's not regulated. It could be whatever they want it to be, unfortunately. I've seen pet deposits that are monthly. I've seen extra rent added for pets, right? And I don't know, we'd have to ask Shannon when she comes back or tomorrow if that's something people can do, but I have seen it. And I've also seen the pet deposit be $500, $250. I've seen them vary. I've also seen people not accept pets based on the weight of the dog. I've also seen them not accept based on the breed of the dog.
Are you able to brush up on the emotional support pets over here?
They can't say, apparently they can't say no at all.
Right, and I believe they cannot charge, and I don't know, maybe Deb knows, they cannot charge deposit or rent for those pets. That was my understanding. But.
Yeah. So
right.
Yeah, they can't. So I will add that people, this is a little out of control with the emotional support pet, right? My wife is a teacher at Washington Lee High School, and one of her students has an emotional support mini horse.
Mini horse?
Mini horse.
I had someone apply for a property when the landlord did not allow any pets. They said maybe a small dog. Someone applied with 200-pound dog. There was, what is it called? A Bernard or whatever, those huge ones.
Saint Bernard.
Saint Bernard. They were a support pet.
You know, Drew, the airlines have really restricted back. I think now most airlines don't allow support pets because people take advantage of it, and they're only accepting a certification of a service dog. So this may change moving forward in the future, but I know that the airlines, that you cannot take a quote unquote emotional support pet on the airlines anymore.
Right. So far is American, Delta, and United.
Okay.
Yes.
So yeah, I don't know the
Airlines too. Southwest Airlines stopped allowing emotional support, and as a service animal, it's only think it's only a dog.
Yeah.
Can't be a cat or a turtle or a horse.
And you have to have the certification alongside with the documentation from the doctor and the place where they've been trained.
Oh, wow. If I made my wife an emotional support wife, could she fly with me for free? just wondering. Anyway.
Listen, wait, I got one more thing. My client is charging $50 per month to have a pet. So you're saying that might not be allowed?
No, I don't know. Again, I haven't done one of these in a while, and I'm not up with all the rules.
Yes, it's allowed. I have a client, the last one, that they charge 100 monthly.
Okay, so you can add extra to the rent instead of
Yeah.
a deposit, or do they do both?
No, so in this case, I was the listing agent, and my client asked me to add 100. So you add with the payment monthly.
With
the monthly.
That's for the support animal?
No,
No,
for
no, no.
any animals.
For any animal.
Yeah, some of the MLS listings, because I've done a couple of rentals, some of the MLS listings require a pet deposit and at the same time additional
They can
fee
also
for
ask.
the pet. And the highest one that I've seen monthly was $350.
Oh. Yeah, for us was 250 as deposit plus 100.
Yeah.
Wow. Wow. Well, pet hair and pet, other stuff can damage your property, right?
What about the service dog, like a service animal?
Somebody's talking, but we can't hear you.
I think it's Pawasha. She's asking about service animal.
Oh, well, we just went over that.
Yeah,
Right.
you don't charge, they can't charge for service animals, not even a deposit.
As long as they're certified and you have
Right.
they have proof of certification. Okay, we're going down a rabbit hole. I'm glad the airlines are doing something about that, but next. This is all self-explanatory, right? You can go over this with your client. At the time that if they have a pet, you let them know. If you're going over this with them ahead of time, let them know that the pet deposit is decided by the landlord and can vary. And there can also, now we know that there can also be an additional charge monthly. Okay, so let's go through that. Okay, and this is an addendum to the lease. This is just like a sales contract addendum. Please, 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 please do not try to make your own language on an addendum. There are people that get paid a salary to tell you how to write this. Two people I reach out to whenever I write an addendum is my favorite title attorney, David Robertson, or Shannon. I never try to do the language myself, even after 11 years. If it's something that Shannon hasn't told me before, I don't do the language myself. Please remember that. This is just a notice, right? We're leaving in 60 days. Love, your tenant. Sign. Okay. We will go over this even though I don't want to. I'm hungry.
You can do it, Drew.
It's close to lunchtime. If I pass out, you guys call 911 or call Chris.
Don't think about it.
Yeah.
Yeah, someone call. If I pass out, call Chris.
Okay.
All right. So this is a standard exclusive right to lease the listing agreement. It's very similar to a listing agreement. Okay. I mean, very similar, just talks about a lease. So again, date, landlord's name, KW United. Date, landlord name, brokerage. Okay, the same language as in the other one, the appointment of the broker. What you're going to do. I'm going to appoint you as to my broker. Okay, cool. Address of the property. Self-explanatory. Please, if the landlord lives in a different location, please put this here. Please fill this in. It'll be useful later on down the road when the tenant calls you and says, hey, I can't find my landlord. I don't know where to pay my rent. And then you can just look it up because it happens. Brokerage. And you guys all have an email that you know to put there. It differs depending on which market center you're in. Term of the listing period. Again, same thing here. I do not do it for less than 3 months. On a listing, I would prefer, on a rental listing, I would actually prefer 6 months. If he says, oh, let's just do it for a month and see what happens. Do it for yourself for a month and see what happens. I'm not going to spend my money and have you decide in a month that you want to do it yourself. Okay, so here is instructs broker to offer premises at least at a minimum of how many months, right? Do they want a 1 year lease, 12 months, or do they want a 2 year lease, 24 months? That's what you put here. But not to exceed, maybe they don't want a 36 month. I don't know. If they don't care, then you leave it blank. If someone walks in and says, we'll lease it for 5 years and they're okay with that, then you put nothing there. Here's the max amount of monthly rent that you guys have agreed upon. That's the max. Put that there. Now, when will it be available? That's next. This is a question that you got to ask them for. This is for the Section 8, right? So it reads, as of date, which is the date of this contract, landlord owns more than 4 rental dwelling units in the Commonwealth. That means in Virginia. He owns them individually or through an LLC or an S corp, or more than 10% interest in more than 4 rentals. So you just have to ask them, do you own 4? Do you own 4 or more? Yes. Landlord must consider applications from prospective tenants who qualify for Section 8. So if he owns more than 4, he has to consider these Section 8 vouchers. If he doesn't, then he can decide whether he will consider them or not here.
So is there a reason?
Yeah, we're going to ask Shannon to explain it in the right language, because I'll butcher it. You just have to make sure that you ask them this question, because they can get in trouble. It's become a violation now. And I believe it's a fine, if I remember Shannon telling me it was a fine. Let me check the chat. Oh, sorry, I wasn't paying attention to it. This is a new document. This is the updated listing agreement for a rental. Yes, it is. Sorry, let me turn that volume down. Okay. Okay, the chat is on fire and I don't normally see it. Oh yeah, absolutely. You're welcome. So landlord will allow, oh my goodness. Okay, thanks, Johnny. Next time, yell that out, man. I'm not monitoring the chat. Johnny says he has 27 rental properties and he does consider Section 8 vouchers. Thank you. Landlord will allow smoking. Landlord will allow pets, yes or no. And then the restrictions. So if they say, Anya, I will allow a dog, but nothing over 100 pounds, nothing over 60 pounds. That's where you want to put this. And then the pet deposit goes there. And then a list of these conveyances, right? What the property has, what the property doesn't have. The repair deductible. You guys all know what this is for? Anyone not know what the repair deductible is? Okay, I'm going to explain it.
Is a home warranty.
Yes, thank you, Lee too. You are the man. If you have a home warranty, if your landlord has a home warranty, he can make the deductible a requirement of the tenant. So if the washer, if he has a cinch home warranty and the home warranty deductible for repairs is $100, here's where he would put $100, and in parentheses, you can put paid by tenant. Or if it's not, if the owner's going to pay that deductible, paid by owner.
Drew, does this only, the repair deductible, does that only apply if there's home warranty?
Well, that's usually where you get a repair deductible only. Homeowner's insurance, there's not much of a deductible if something happens that bad, or renter's insurance, right?
But if there's a owner that has a handyman that they send him out, you can't just
This is
have
for
a
the
fixed
deductible.
number.
Yeah, this is for the deductible, and that's what you want to put. You can make that certain, in the lease, you can make that which repairs are responsibility of the tenant and which repairs are a responsibility of the landlord. Right? If they move in and in a month the dishwasher breaks, right? It's up in the air. Okay, so included in rent, question mark. See that? Question mark. So when you fill this out, you do, no matter what, you check public. But then you go over here and is it included in the rent, yes or no? And you do that for all of these. Right? You guys got it?
So the utilities and major systems that are checked yes, those would be paid under the repair deductible by the landlord because they're checked yes, that are included on the rent, or we have to make a separate list of which utilities would be paid by landlord. And
well, let's just use the example of a condo, where the condo fee includes electricity and some, maybe water, right? Water, sewer, and electricity are all in the condo fee. You would check that the water is public, but it is included in the lease. If your landlord, normally, if the landlord has these utilities that are paid by them out of pocket, it usually is a requirement of the tenant to pay these, to get their own utilities. But if they're paid within the HOA or condo fee, then it usually is included in the rent. And on a listing, you'll know, or the landlord may know. If not, you'll have to just look at an old listing from that building and see that it's all included.
okay.
Drew, who better than you can explain me this? And I always want to ask, but you are here and I want to ask you, can you go up, please, where it says a little bit up? Can you please explain the difference for me? That, yeah, 0.6, a little bit down.
Okay.
Here, okay. Can you please explain to me the difference between water treatment system, window AC unit, window fan, and window treatment? I always confused. And I want to be here and I want to be recorded, so maybe later I can go back again and write by myself.
Okay.
Thank you.
All right. So you want me to explain not what it says in 6, but the difference between a window treatment?
Yes.
And
what is a water treatment system? What is window AC unit? What is window fan? And what is window treatment?
okay,
What are
so
the difference?
a window treatment could be blinds, right? The client may not want to take blinds down, so they may convey, right? A water treatment system is just if they have a water purifier, right? Some homes have it. Some homes, if you have well water, if you go further down, out or south or anything like that, they have, hard water or a water treatment system. That all that is just cleans the water. A window air conditioning unit is that stupid thing you see people put in the window, right? And it plugs in and they turn it on and it blows cold air out and then it sits out the back. That's a window air conditioning unit. A window fan is just a fan that fits into a window that plugs in. It doesn't provide cold air or hot air, it just provides air.
Great, thank you so much.
You're absolutely welcome.
Hey, Drew.
Yes.
What does, and maybe Deb, I misunderstood. I thought that window treatments in this particular section are considered curtains. That
Could be.
blinds are actually part of an attached to the.
Yeah, could be.
Okay.
That's correct. I apologize for jumping in, but that's what Shannon spent a good amount of time yesterday or the day before that to clarifying that when you go to 6 and you read the paragraph, what stays, blinds and shades are fixed because they're attached with brackets. So that stays. The window treatment in the check boxes only applies to curtains. So any sort of fabric, shears or whatever.
Yeah, and so you have a gray area, right? And the gray area is always the fixture, right? What stays, the fixture or what's attached to the fixture? So if somebody really wanted to be petty, they could create a gray area there, right? You have a TV mounted on the wall and it's considered a fixture, is it? Or is the mount considered a fixture?
The mount.
The mount would be the fixture and the TV would be the personal property.
Right.
So Anya, so
Because
this
it's
is
whatever's
window
directly
treatment.
attached to the wall.
Right.
So if windows treatment is the curtain, the blind, where is?
Up above, Veronica, you have to read the paragraph 6 when it talks about 6A, personal property and fixtures. In the verbiage, line 1, 2, 3,
third line.
Third line, it says window shades, blinds, window treatment hardware. And Shannon talked about the brackets for hardware because there might be a confusion. If it's fixed to the wall, it must stay. I had an issue in the past when my clients took the rod and it became a problem from the buyer because they were all offended that the rods were taking, but only the brackets were left. So from now on, I tell my clients your rods and hardware should stay because sometimes you can't determine whether the rod is really a part of it. Maybe there was already a fixture in there.
Perfect. Great explanation.
Mm-hmm.
All right, so where were we? We were at this.
Utilities.
Yeah, and then we're down to number 8 here where it says you're going to use a standard lease from VRLTA. Okay, here's what goes through your duties. Right, this is all mumbo jumbo. You can read. I don't want to go over all of that because we're pushing on 12 o'clock for you guys. So, and me. The broker shall or shall not install a for rent sign, right? Depends on where the unit is or where, if it's a house, you may want to install your own sign. Remember that the profit margin on these are very small. So maybe you get your own yard sign that you can just push in the ground instead of having your company go out and charge you $60 for it. Maybe you get your own. Will you install one or not? Yes or no. Okay. And then all of this is in the listing agreement for a purchase as well, right? Do you get to market it on Bright is what number 10 says, right? If they allow you to market on Bright, how long till you get it on there? Right? Broker shall enter the listing information into MLS, check this box within 3 days of the commencement of the listing period or on or before, and you could put a date. If you get this agreement signed and you're not going live for 30 days, you don't want to check the first box. You just check when you plan to go live.
Can I ask a question?
Yes, sir.
Deb, the last time I took the boot camp, you explained this in a way that it was something about like putting the date and it was like a 30-day period or something like that. Can you just like clarify what you meant by that? If Deb is still on.
I'm sorry, ask the question again.
So
What's the question?
So and 10, when you're listing in the MLS, And you said you normally don't check 3 days. You actually put a date, and you gave a reason why.
Okay, so let's say I'm meeting the client today and they say I want it on in the next 2 or 3 days. And I say 3 days, but then all of a sudden they call and say something's gone wrong. So by doing the next line down, again, this is a personal choice, but I found due to experience and what's happened with me a few times, by choosing the next one where it's on or before a certain date, because it says on or before. So if I say 10 days out and my client says, yes, we got the carpets cleaned, the house is ready to go, so we can do it on day 4 or 5. And we don't have to have an additional addendum to change anything. Does that make sense, guys?
Yes.
Okay.
Because of on or before, you could put the date further out, and since the contract states on or before, you could do it before. Great. That's the way to do it.
And a simple email between you and the client to say, let's go live on such and such date. Yeah.
Number 2 is if they don't want it listed on the MLS, right? Then this gives you permission to. Here, we'll give you permission if you check this, like buy a Facebook ad or Craigslist or wherever, for rent.com, whatever site. This here.
Back up a little bit, Drew.
Okay.
They have the last sentence there. They have to provide a waiver to MLS.
Okay. If you're at a listing appointment and the person doesn't want you to market it on Bright, my opinion is run, right? Or talk to Shannon about getting the waiver. The good thing is you should try to tell them that Bright's probably a good thing to do, in my opinion. Those are just the opinions of Drew, though.
Well, it broadens your funnel of everyone seeing it.
What Deb said. The landlord authorizes broker marketing premises through MLS, right? And this is if you wanted to hit Zillow, Redfin, Trulia, right? You got to say yes to this. Almost like, I mean, you're going to miss out on 100 potential clients if you don't. But that's just the third-party sites, right? So that means it'll go to your internet site and licensed real estate salesperson. So if you search an address that's of a house that's for sale, you'll see if it's a Keller listing. Sometimes it shows up on a Caldwell Banker site. That's all that means. And if they opt out of marketing it on the MLS, then this is the landlord authorizes or does not authorize display of premises address on any internet website.
So for the lease, it's just pretty much the same as it is for listing the home that
Yep.
went over. Okay.
Yep. This is just permission to go on third-party sites.
Yep.
If, again, Zillow has us a little bit by the feet. If your client says that they don't want the display of unedited comments and they don't allow it, then it won't go on Zillow. So you got the lesser of two evils. The automated estimate, if they don't like the automated estimate, tell them to authorize it, but then they can go in and log into Zillow and change it, or give you permission to go in and change it. This is for coming soon. If you have a coming soon rental listing, this just means you're allowed to do it. Remember to be mindful of your dates and be mindful that Bright is fining people if they go past that date. Again, same as before, this goes over the definitions of each representation. So the landlord can see that. The landlord should definitely definitely agree to designated rep for sure. You can discuss dual with them. You can discuss dual and explain to them that if somebody came in and wanted to rent it from you, would they be opposed to you handling both sides? If they say they are opposed, then say they do not consent. Broker compensation, we all know 1 month, right? Now, this is a tricky one, days after, right? If you listed for 3 months and on day 92, someone who you showed the property to walks in with an application, do you want to get paid? I say yes. I put 10, 15 days there. Some people put 30. I've seen 30. Just like this, just like a listing agreement, if the tenant agent brings someone, how much are they going to get? Are you going to do 50-50 or are you going to do 75-25? That's entirely up to you. Most of the time I see 75 to the listing, 25 to the tenant. Now, if it's been on the market for a while, I have seen it go from 25 to 50 to try to entice realtors to bring their clients there. I have seen that happen. Other compensation, if your client says, hey, if they move in before February 1st, I'll give them a $500 off their first month's rent, or a $500 agent bonus. Sorry, I'll give them a $500 agent bonus. That's where you would put that. If you do a retainer fee, that's where you put that. You can, if you want. I don't. Early termination. For me, and I don't know if Shannon or Deb agree with this, in D here, I will put marketing fees. I write it out though. And then I keep all my receipts for anything I spend to list the property. So if I listed it and in a week they decided they were going to move back in it because after they cleaned it up, it looked really nice. And I had some photos done and I had a sign put in and I paid for an ad. I would want to recoup those expenses if they didn't go the term of our agreement. So I put marketing fees there and then I save all my receipts in a file. Purchase by tenant. If you find a tenant and during the time of the lease, they decide to purchase it and you want to get compensated for that, that's where you would put that. You guys understand that?
How many did you put?
Put whatever you want. Put 1% of sale price. Put 2%, 3%.
And how many days you put?
There's no day. And
Yeah, it says
within.
I usually put like 60, so
Yeah.
they can't, so they have to
60?
move out for a while before they can do it.
60 is a good time. 30 is a good time. I'd prefer 60. I agree with that. Number 14 is important. You want to be able to disclose other applications. Period. If Johnny's got 27 homes and he puts one to list for rent and people are calling and do you have any other applications? He says, yes. How many? I got 5. What are they for? They're all for $2,000 a month. That could behoove him because if somebody really wants the property, they could say, well, I'll give you $2,100 a month. Fair housing, we all know, we better know that. Make sure your people know that. They're not going to be part of a relocation program. We don't offer that. And if you work with one, then you would check yes. If it's in a condo association, right? Just where you make sure you get the lease to the condo people in time. Let them know about the move-in. What are the other fees here? Fees in addition to monthly charges. Move in. Is there a parking fee? Is there a fee to use the pool? Is there a fee to use the tennis court? On my rental property, all of that is included in the condo fee. And so when I do a tenant here, I just I just say it's included at the landlord's cost.
Drew, the package association, do you always provide by the landlord cost or at the tenant cost? What normally you put?
Most of the time they don't make you show them the packet, right? If they do, it should be at your cost.
Drew, over here, it's not
The landlord needs to provide the rules and regulations to the tenant because the tenant has to be aware, period.
Yeah, and
so always at the
resale.
landlord's cost.
So is mandatory, right?
It's the bottom line rules and regulations. It's not the financials. It's not the resale. There's usually a separate rules and regulations. Like you can't have commercial property. You can't have commercial vehicles on the property.
Most landlords have have it in a folder. And I have one, it's in a 3-ring binder in one of those protected slips, and I leave it there. And I just give it to each tenant. And it's just rules, regulations, like Deb said, what you can and can't do. Lead paint. This asks about the liens. You can go into that with them. Just ask them the question as you go through it. So this is the representation and warranties, right? Landlord is aware that the landlord may be responsible for failing to disclose information or misrepresenting condition of the premises. If you know there's mold there and you don't tell them, you're responsible, right? I think number 2 is about if someone tries to sublet the property, right? So don't know, haven't done this in a long time. If the landlord is a licensed realtor or was a licensed realtor inactive, then you would check there. Landlord has no knowledge of an underground storage tank. Premises is or isn't currently tenant occupied. These are all self-explanatory. Let me see, additional terms. So we're at the end. Let me see, there was one in here. I think this one is to make sure that your landlord keeps their homeowner's insurance. Like they understand, yeah, this one. They have to keep the landlord has to keep homeowner's insurance, even if the renter has renter's insurance. You got to have homeowner's insurance. Make sure you let them know that. Okay, we're at the end. There's the lead paint. Same as a sale. And make sure that you and the tenant's agent initial and sign. Any questions? 5 minutes left.
Great job, Drew.
Oh, and anything for you, Deb. As soon as you feel better, never ask me to do this again, please. Thank you.
Thanks, Drew.
Tell us how you really.
Thank you, Drew.
You are absolutely welcome.
Thank
I'm
you.
always going to tell you how I really feel. Do you guys have any other questions or we have 5 minutes. Do you have questions about something that doesn't pertain to this?
Hey, Drew, just a quick question, just I guess general question around leasing. If an individual makes a leasing contract for a 12-month period and they have some kind of emergency, they need to break that lease, what is the penalty or some kind of, what is the, I guess, fee involved, or how would they go about doing that?
Well, it depends on the landlord. 2 things could happen. They could owe the remaining balance of said lease, because in the lease, remember, it states how much per month and then the total of those payments, right? Or if the landlord's nice and could say, hey, you find a tenant and I'll let you out, right? There's a couple different ways, right? Did you see when we were talking about if a person's job, right? Yep, that's what 90% of the time, Johnny, you're absolutely right. If a person's job relocates them more than 50 miles in the lease, then they can get out of the lease legally.
Got it.
50 miles.
Yeah,
Also,
50
a
miles
quick
or more.
question.
Yep.
I see this when dang, I forgot to exit. I forgot what I was asking. Hold on one second. Oh, when you're filling out a contract and it says, you know, is this person does this person have a real estate license, active or inactive? Does that mean like if they've ever had a license at all, or is it just right now?
Ever. No matter
Ever
what
in life?
state.
Okay.
Okay,
And
but
does it
and the
have
next
a
one.
change in the, is it just for knowledge purposes or does it change something in the contract?
Someone who had been a realtor may have a little bit more knowledge and expertise in the field that you're working in, therefore given an advantage over someone who's not, period. So it's really a FYI, CYA type thing, period. I've known many realtors who have no knowledge whatsoever. I'm sorry, take us off recording.
That's literally me right now. So you're fine.
You sorry, you said that based on the COVID, no, it can happen and the person can lose the job. So in this case, they are entitled to, you know, to don't kick the landlord cannot kick them out. For how long? How it works? For how many periods? You know, for how long is, you know, the landlord can say, okay, yeah, you are entitled to be there without to pay rent. How?
We got to get Shannon on that one.
Well, that would be what the moratorium ends.
We say sorry?
The moratorium is on this COVID thing. I didn't read up on it for renters. Sorry, I wasn't prepared for that question.
I believe it changes, depends on.
It's going to change every 60 days, I believe, from starting when they did it for 60 and then 60.
Yeah.
Right. I believe right now it's until July or end of July, I believe, but I'm not 100% sure. I saw some